Our final day of University System of Maryland's Wills and More Week. I hope you've been enjoying the sessions as much as I have. Delighted that you're taking the time to be with us again to learn about this important topic. My name is Ann Kolakowski. I'm the Director of Gift Planning Services here at the System office. And before we dive into our final topic, I just want to cover again a few housekeeping items. So we are recording this session and we'll be sending out an email early next week with links to all the sessions in case you missed any of them, as well as a short survey that we hope you'll take a few minutes to complete so that we can plan for next year. You may or may not see a chat option in a moment. We are trying to enable that if possible, but if not, there's some points in the session when Malini is going to ask for some answers. So we may just jump into the Q&A window for that. Which will make the feature of upvoting actual questions all that much more important. So if you see that little up arrow and you want to make sure it gets addressed at the end, please go ahead and mark that up. And lastly, just a reminder that this, like all presentations that we've had this week, is being presented for informational purposes only, and the content should not be considered as a substitute for legal, tax, or financial professionals. So it's now my pleasure to introduce today's speaker, Malini Ganvir. Malini is the founder of Ganvir Law, LLC, a boutique estate and business planning firm serving families and business owners through Maryland. She is passionate about helping people protect what they've built and avoid leaving behind a legal mess, which is actually what we're going to really focus on today, like not leaving that mess for somebody to have to clean up. So through clear, practical guidance, Malini shows how planning today mitigates risks, strengthens asset protection, and ensures both family and business are cared for with intention. Known for her engaging teaching style, she regularly speaks at community events. Fun fact, I met her at a pizza and Will's presentation, which was wonderful, and educational programs to make estate and business planning approaching, empowering, and impactful. And here's the best part of all, Malini received her BA from the University of Maryland, Baltimore County, and her JD and LL.M from the University of Baltimore School of Law. So she is a triple Maryland degree holder. We're just delighted about that. So welcome, Malini.
Thank you so much, Anne, for for inviting me. I'm really delighted to be here today. And as Anne said, we met at a seminar earlier this year. And yes, there was pizza there, Anne. So it's really an honor to be part of this estate planning awareness series this week to help really better educate and prepare you for one of life's inevitabilities. Not to be Debbie Downer here, but this is something that all of us are going to have to deal with, right? At some point or another for a loved one. And then our loved ones are going to have to deal with it for us. So this is really geared towards empowering you and how to make some of those decisions better. So I know Anne had mentioned that we're not quite sure what's going on with the chat function. So if you guys don't mind, if you're seeing a chat function, can you go ahead and just drop a hi in the chat so I can see if this is going to work or not? Give you guys a couple minutes, and if I'm seeing no chats popping up, or Anne, if you don't see any either, then I'm going to assume that it's not going to work.
Yeah, I think we're chatless.
We're chatless. All right. So I know you guys heard about Anne saying that I had an engaging presenting style, which I do, but I feel like I have one hand behind my back. So we won't be able to interact as much as I normally do. Totally fine. We still have a lot of valuable information for you. But in your own minds, or if you're sitting in the office with someone, a coworker, whatever, how many other webinars did you attend this week? Think about what you learned. Why did you do this? Why did you take time out of your day to come learn about estate planning stuff, right? So we are going to focus on just one very small aspect of estate planning today. And as you can see from the slide deck, it's choosing the right estate representative, or if you're serving as one for yourself. Right. So let's go ahead and dive in.
And just to jump in real quick, so people are using the Q&A, and that's just fine. We can use that as a substitute for the chat if you want to go ahead and just throw the questions out that you want.
Yeah, where are you able to see the Q&A, Anne?
I can see the Q&A.
I'm able to see it on my end.
Yeah, it would be up at the top. But
Seeing the
yeah,
chat
we're
function.
all learning
Yeah,
Teams
we're
this week. Yeah, we're learning Teams, so it's a little bit different. So thank
yeah,
you all
it
for bearing with
definitely
us.
is different. That's all right. So, and if you don't mind, since I am not able to see the Q&A for whatever reason, I'm only seeing the chat box. Um, for those of you, I would love to know if anyone else here actually attended another webinar this week. Say yes, and then put in how many. And Anne, if you don't mind just reading off a couple of the responses that you're getting, that I'd
Sure.
appreciate.
Happy to help.
And while you guys are in the Q&A box, what did you learn? What's one big takeaway that you've learned so far this week? I realize it's a heavy topic,
Yep.
really.
Let's see. I'm seeing, let's see, some people 1, 1, 2, 4, 3, 3, 2. So people are sort of throwing out the
Yeah, a
numbers.
good mix.
Yep, this is the 4th.
Perfect.
I learned how to make a plan. I've been to all of them.
Perfect. You
Yep.
get a gold star, whoever that person is. All of them learned how to make a plan. That's what we
Oh,
want. That's the goal of
this I
this.
love. This was from yesterday. This, yes, I went to 2 sessions, and estate planning is an act of love. That's super.
Yes, that is actually
Yes.
something that I say, and I'm sure you probably remember that. Like, doing
Yep.
estate planning isn't actually about you. It is
Yeah.
for the people that you leave behind, and it's really a gift when you do this planning so that you're not leaving your family with a mess. So awesome. Cool. So, would it be helpful to everyone to dig into what it means to be an estate representative? How do you go about actually picking who those representatives could be? Just give me a thumbs up, yes, in the chat, and let me know if what you're seeing on your end.
Well, if you've never been in this role and I have, you should be putting yes in that Q&A box because it's a lot, but it is an act of love as well. So the carrying out the plans.
Perfect.
Yeah.
And while you guys are doing that, let's go ahead and just a little bit about me. I moved on to the next slide deck. As Anne said, I am a triple Maryland degree holder. I was born in Maryland. I've never left. Still live in the originally from the Eastern Shore. Now I live in the Baltimore area. And I've been in the legal field for over 20 plus years at this point. And I've had my own firm for 12 of those years. And in the 20 plus years ago, I worked for an attorney who did business, real estate, and estate planning. And when I started my practice, I said, I'm not going to do estate planning because it's a lot. It really is. There's a lot of admin, there's a lot of logistics. And I just started doing business in real estate. I absolutely love doing business in real estate. I still do it. It's an active part of my practice. But then I had my son. I don't know if there's a bunch of people on the webinar today that also have kids, but that was a pretty big life-changing event for me. I'm venture to say that that was probably a big life-changing event for a lot of you too that have kids. So that was my trigger point. That was my life event that led me back to estate planning. In the process of doing my own family's estate plan, it really reignited my passion for doing this to others, doing this for others, because being proactive in mitigating risks, identifying what those can be, and then using the legal tools and techniques that we have to mitigate those risks, that is what estate planning is all about, right? Identifying how you cannot leave your family with a mess. So our office is based in Falston, but we have a very heavy virtual practice as well. And we have clients all across the state. We're also licensed in DC and soon to be licensed in Pennsylvania. All right. So about our firm, right? We are actually a firm of moms right now. That's everyone that we have is they're all mothers, and our goal is really to make estate planning as stress-free and meaningful as possible. It's more than just money. It's more than just assets. It's really doing what you can to make things as streamlined as you can for your family, to minimize the chance of court or conflict, right? It's making sure that they have that up-to-date, clear, concise plan in place to not leave your family with a mess. All right. So, a couple questions. Why did you come today? You guys don't mind dropping it in the Q&A, and Anne, as you're seeing those questions roll in, I'd love to know, like, what about this specific topic made you come today? Seen anything in the chat, Anne, or the Q&A? And you're on mute.
I'm on mute. I did it. Yeah, no, nothing yet. You can be
Okay.
anonymous if you have a reason to throw in there that you don't feel comfortable sharing. You can just keep it keep it
Well, I'm
under.
going to assume that no one forced you to be here. So I think it's safe for me to assume that this is something that you were interested in. So next question is why, do you have a plan in place? Do you have a will? Do you have a trust? Do you have advance directive? Do you have a living will? Do you have the financial and medical powers of attorney, right? Feel free to drop it in the Q&A if you want, but really this
Okay.
is something that I want you to ponder on, right,
So
as individuals.
it looks like there's a little bit of lag with the Q&A showing up because we have a lot of answers in there.
Oh,
So
okay. Well, let's
I'm going to
pause
just
and
read
let's
them
hear
out.
some. Yeah,
Yeah.
perfect. Thanks, Anne.
I missed a couple of sessions this week. I hope my question isn't a duplicate. Oh, that's an actual thing. So I'm going to skip that for a minute. I will be an executor. I need to do my own plan. What questions to ask when looking for an estate person? I'm struggling to figure out who to name for the required roles. They're really big
Yeah,
questions.
that's a big one.
I'm near retirement. I need to make a plan. I'm trying to get ahead of the game for when the wife and I retire.
Yeah.
I'm up in age and trying to plan for the future and for my children's future. To identify who among the relatives will be the state representative.
Yeah, perfect.
I thought I could do my own estate planning, but maybe I can't. I've been asked by family to be an executor, to learn to plan estate. Whoops, now I gotta scroll back a little bit, so bear with me. Yeah, we do have a lot of interaction here. Thank you for doing that, folks. Trying to get equipped with information and knowledge to know what to expect. And now we're moving on to, do you have a plan? We have a no will yet. I need assistance with all documents. We have the will, not yet. Yes, all of them are completed. Gold star to whoever anonymously
Absolutely.
posted that. Yeah. No, and that's why I'm here this week. I know it's time. You bet.
Yeah.
Not yet. I don't have anything, which is why I'm attending. Good for being here. I understand more of what I should be doing since I am named and what it means to ask others. Okay, so that's getting back to the
Yeah.
why are you here? Not
Perfect.
yet. I'll definitely be working on it. And whoops, let me see. One more. My plan's outdated. And the person who did my plan earlier doesn't do estate planning anymore. I need to find a new planner. I have no children. Who should I ask? I don't have a living will yet. As a new homeowner as of 2024, I realize how important this is. And I have nothing yet. This is a goal of mine. So yeah, those
Awesome.
are great feedback. Thank you all for sharing.
Absolutely. I echo Anne's sentiments. Really, thank you guys. This is, I'm asking this question not from a place of judgment, but rather reality check for everyone here, right? Let's see where you are, learn what you can do to fix that. Because one of the things that I share frequently in my estate planning seminars is, if something were to happen to you guys on your way home from work today or going to the grocery store or whatever it is, I venture to say the vast majority of you would leave a mess for your family. I'm going to let that sink in for a moment. The vast majority of you will leave a mess for your family. Here's the good news. You're alive, and I'm assuming all of you, if not at least most of you, have the competency to actually sign legal documents so you can fix this, right? And you've taken a really big step in attending here today and attending some of the other sessions this week and really focusing on getting educated about this topic, because estate planning is one of those things that no one has to do. No one has to do estate planning. But the reality of that means that when you do not put your own plan in place, the government has one for you. And if that is not in alignment with what you want, then you need to put a different plan in place. So I know there's been a bunch of other topics. We're going to super focus on just the trustee part, either selecting one, the executor part, or serving as one yourself. So let's go ahead and move on. All right. So quick thing, drop it in the Q&A. Who has served as an executor or trustee? If there is anyone here, I would love to know. Would love to know.
I know we have a little bit of lag time. Yes, I have done it. I did it for my
You
aunt.
have, Anne. Do you mind sharing a bit about your experience? I know I'm putting you on the spot here.
No, that's fine. No, it really opened my eyes. I had no idea what was really involved prior to serving in that role. And I did make use of an estate attorney to help guide me, because it's a lot of responsibility and I really don't want to mess anything up. So, there are limits on how much an attorney can charge. Like, it comes out of the little bit that you're allowed to compensate yourself as personal representative. And again, like, it's job. So, I firmly believe, and it wasn't a lot, but I was happy to share some of my portion so that I could get the right guidance, because the last
Yeah.
thing you want to do is mess it up. Yeah. So,
Thank you for sharing that, Anne. I
yeah, of
appreciate that.
course.
Yeah.
Let's
Okay.
see if we have any other thoughts. Um,
Sure.
somebody's been one before. I've done it for my dad. I've been an executor and a trustee. There you go. A lot of people, have not done it. So it looks
Yeah.
like we've had a handful who've had that experience. So
Yeah. Awesome. Thank you guys for sharing. Well, let's jump in. Why the right representative matters, right? Executors, trustees, financial and medical agents, they are the ones that make your plan work or not work, right? That's why selecting the right one is really important. Choosing the wrong person can unfortunately create delays. It can create conflicts. It can create loss of value of the assets that you do leave behind. And really, in making that right choice, it provides an opportunity to have an easier, more efficient, more streamlined process that leaves family in a state of harmony rather than conflict. Um, I'm sure this comes as no surprise to you guys. Grief can do weird things to people. Money can also do weird things to people. And when you put grief and money together, it's just an even more weird situation that really, unfortunately, can can break families apart. Just from a personal note, when I had a grandparent pass away, there was a pair of scissors that actually created some conflict in the family. I kid you not, it was scissors. It actually wasn't the scissors, but all the memories that were tied to the scissors. So it's sometimes even getting along in life, it's not a predictor of necessarily being no conflict afterwards. So anyway, um, legal language is super, super important in having the right documents in place, right? Obviously, that's, should be 101. That comes as no surprise to anyone. However, assuming that we have the right legal language in place, we need to make sure we have the right people in place too, because they are the ones that have the fiduciary responsibility to actually carry out what your wishes are. And as Anne had shared, it was her responsibility to act as that representative, but went out and got assistance, got professionals, and you can certainly do that. But the fiduciary responsibility to carry out those wishes fall on your shoulders. So here's an example of a bad experience when the wrong person was chosen. So I actually had a client that had selected the oldest kid because that's a common thing that parents may do. Oldest kid, go with the oldest one. But unfortunately, the oldest one was not the most on top of everything and did not do what he should have done and missed deadlines. And it created more mess and loss of assets in the administration of that. That's just super quick example. Otherwise, on the good end of the spectrum, if we have the right person who's on top of it, they seek the advice that they may need. It could be from an accountant, it could be from an attorney, could be from a financial advisor. Those are some of the three key advisory roles that we see that can support someone through the administration process. Someone who did that, right? They were on top of it. They were able to process everything much quickly. Assets were preserved, taxes and returns and forms and filings were done on time, and just allowed for a much more streamlined process. So the people that you choose is that bridge from the documents and the decisions that you've made, the language that you've put in place with your documents, to the family outcome, right? What actually happens, who gets it, and when they get it. It's that person that you name, it's their responsibility to make sure that your wishes are carried out, right? So, all right. So let's talk about what the key roles here are in an estate plan. So one of them is an executor. Personal representative is another term. They're same thing, used interchangeably, but someone who is serving in that role is going through the probate process. They have the fiduciary responsibility to manage the probate. So without kind of turning this into a whole probate thing, if you pass away with no will and you have assets that are required to go through probate, you'll go through probate. If you have a will and you have assets that go through probate, you will still go through probate. That's a common misconception that wills avoid the probate process, when in fact it's a one-way ticket. So it is that executor or personal representative's responsibility to make sure the wishes that are set forth in the will are carried out in the context of the probate process or estate administration process. The terms are used interchangeably, and that's a court supervised process. Another role that could be in your estate plan is a trustee. So this really only comes about if you have a trust in place. There are many, many different types of trusts. There are revocable living trusts. That's really the foundation trust that is frequently and commonly used. But there's also an opportunity to have a testamentary trust. And those are trusts that are not created, but the language is put inside of a will and it springs out of that will. It becomes effective only upon death, right? So you could have a trustee even within a will to the extent that there's a testamentary trust that's built within the trust itself. But they have the responsibility to follow the terms of the trust, to manage the assets that are in the trust. So it, to some extent, fairly similar to what the executor personal representative does, but in much different context, right? That probate process versus the private trust administration process. And certainly the terms of the trust or the terms of the will really dictate what that process looks like. It may be you do it, you're one and done, or it may have a trust that's continuing in nature, which certainly will impact the longevity of the role. Power of attorney. Another term that's used for that is agent, right? There's two main categories in which this comes up, and that is financial and medical. Powers of attorney can be effective, most frequently, especially in the context of estate planning. They are useful if someone is alive, but they are incapacitated. It could be dementia. It could be Alzheimer's. If someone is in a coma, whatever the circumstances may be where someone is alive, but unable to make those decisions themselves, that's where having an agent, having a power of attorney in place for those medical decisions and those financial decisions are super important. Key thing here to note is that a power of attorney, in order for it to be useful, the person has to be alive. The moment someone passes, that power of attorney is no longer effective, cannot be used. So in the last category that we have here is guardian. So if biological parents pass away, obviously a really sad situation, but they need to be in the care of someone, and you have the ability to name those guardians for minor or dependent children. Just something to add here, I know it's not on the slide, but if you have an adult, let's say that has dementia, they didn't have powers of attorney or anything like that put in place, you can go through a court process to get guardianship. So the concept is someone being appointed to take care of someone else is the same, but we kind of have two different categories. When it's someone that's appointed for children or dependent, it could be an adult child, say if they have special needs, or it could be an elderly person that no longer has the capability themselves. Okay. So the key thing about these roles is, you have a fiduciary duty, and I know I've said that before, I'll say it many times throughout our time here today. It means that you are the one that has the responsibility. You have to be honest, you have to be prudent, and you have to be loyal, like loyal to the documents and what they say. You are not in a position of power to go ahead and decide to do whatever you want, right? It's your responsibility to carry out what the legal documents actually say. Another point that I want to make here is people may choose to name the same people in each of these different categories, but it is not required to do so. Here's an easy example. If you have minor children and you're naming your sister to be, first in line to be the guardian of your minor kids, you may say, you know what, they have a great relationship, she lives locally, she would be a great place for the kids to go. But she's horrible with money. Maybe I shouldn't give the kids to her. No. You can absolutely have your sister be the guardian, but we can separate out who the trustee is, assuming if you have a trust. If you have a trust, you have a trustee, that's the person that would be responsible for managing the assets of the trust, therefore the finances for the needs of the kids. It doesn't have to be separated, but it can be, and that's something that you really kind of figure out and go through in the design of your plan. And that's going to look different for everyone based on family dynamics, what your goals are, what your concerns are. Even where people live could also be a big factor as well. All right. Executor trustee. So this is something that I had started to allude to. Executor or personal representative go through that probate process where it's court supervised, assets are frozen. Typically, it can be either a really easy process or something that can be a bit cumbersome and lengthy. But mostly speaking, if it is a probate that doesn't have a large amount of conflict going on for years and years, though the potential exists, an executor or personal representative role is intended to be more short term. Whereas on the other hand, if we have a trustee, and this really comes, it's typically meant to be a more long term role because they have the requirement to manage the assets that are inside of the trust. Big caveat here, this is going to depend on how the structure of the trust was set up. Sometimes people may use a revocable living trust to completely avoid the probate process, but then their beneficiaries are receiving everything as an outright distribution. So that means that the trust itself will not continue once those distributions are made. Others may elect to keep it in the trust where it has some asset protection and has some kind of guardrails in how and when the assets can be used. And when that's the case, we need a trustee that has that fiduciary responsibility of managing the assets, making distributions, et cetera, in accordance with the terms of the trust. Regardless of whether someone is an executor or trustee, still have to keep the best interests of the beneficiaries in mind. That is what your goal is, right? To make sure that you are doing the best that you can do for the benefit of the beneficiaries. Okay. Here's the thing that is not to scare anyone who has been named in any of these roles, but this can create personal liability. This can create personal liability if you do not do what the documents say you should do, which is why it is recommended that you seek legal advice from professionals who practice in this area to help remove some of that personal liability from you, to help you figure out what you actually need to do and not do in some instances, right? So super important. But at the end of the day, you can think of executors as project managers, right? Here's a project, you tackle it. Once it's over, you're done. Whereas a trustee kind of serves in that ongoing manager role. So, all right. Choosing the right person. I know there was a couple people in the Q&A that said that that's a question and a concern, something that you guys were looking to get more information about. So we're going to talk about it. Here's some of the top qualities that we recommend that you take into consideration when you are deciding who the representative can be. And also, and aside from that, not to add extra stress to deciding who can serve in these roles, we recommend that you actually name 3 people in each of the roles that you have, trustee, executor, guardian, financial power of attorney, medical power of attorney. Because what if something happens to the first person that you name, right? I would prefer that you guys have the opportunity to pick who the second person is rather than it being decided by a court or some other process. Also, people tend to name their family. They tend to name those, closest to them. Who tends to travel together, right? Family and friends. So if there is some sort of tragic situation that occurs, some accident or what have you, you may blow through your top 1 or 2 choices. So we want to provide some options so that you have the decision point of who that'll be. So anyway, back to some of the top qualities. Integrity, reliability. We want to make sure that they're going to approach this from a place of integrity, right? And that they're reliable and actually doing what they need to do. Remember the example that I gave of the bad representative just was kind of lackadaisical about it and missed some filing deadlines. That's not really a point of reliability. Emotional stability. If you know someone who's great with money, but if you suspect that hey, they just lost a parent, they just lost a spouse, maybe they will not have enough emotional wherewithal to really handle it. And that's okay. But really knowing the people that you name is an important evaluation point. Being organized, financially competent, right? If they're not great with money, you probably don't want to put them in this role. If they can't find a really important document, you may also not want to put them in this role too, right? People who are good at communicating. Why? Why is that important? Well, because they may or may not be one of the beneficiaries. Usually there's multiple beneficiaries, especially, a common scenario is parents, if both parents are alive and they have adult kids, it goes to the spouse. And then after the spouse, it comes down to the kids. If you don't fall in one of those scenarios, totally fine. That's just a common example that comes up frequently. If people are not communicating with the beneficiaries of what's going on, it can raise questions like what's going on? What's happening? When can I expect this? Why is this happening or not happening? Keeping everyone up to date. takes effort, as Anne said. It's a job. It really is. And being impartial and fair among beneficiaries. Certainly to the extent that the documents are saying everything is to be split equally amongst the beneficiaries, it's that representative's role to make sure that that happens. Certainly, if there's family conflict, that can make it more difficult, but having someone who can be impartial, especially if one of the representatives was named is one of the kids, so you may have a group of siblings. So picking someone that has these qualities is really ideal. Obviously, none of us live in an ideal world, or at least I'm making that assumption. So do the best that you can with what you have. It's not a requirement that you name just family. It could be friends. It could be a company if you feel like you don't have any friends or family that you would trust to do this. Or even if you do trust them, maybe that's something that you don't want them to have to deal with. But there are certainly companies out there that can provide these representative services for you for a fee. But there are companies out there that certainly do that as an option. All right, so let's go over some common mistakes that we see when people are choosing. I already mentioned one of them, picking the oldest child by default, right? Maybe you start with the oldest kid as who you may want to name first, but run them through that top quality. Do they have good communication skills? Do you think they'll be able to have the emotional stability? Run through those and see if they'll, oh, actually, sorry, the slide didn't change. There we go. Common mistakes when choosing. Perfect. Picking the oldest by default. Choosing someone to keep the peace rather than enforce fairness, because keeping the peace does not always equate to fairness, right? So we want someone that even if a beneficiary is unhappy, we want to make sure that they're being fair and following the terms of what the documents are. Appointing co-executors who don't get along, or even just let's take that a step back. Appointing co-executors. This is a common thing, and they say, well, I have 2 kids, I can't choose. They're both great, they're both wonderful, they get along perfectly fine, let's do it. Remember I said grief does weird things to people, and money does weird things to people, and then grief and money together does even more weird things to people. When you have co-executors, from one approach, you may say, well, then there's 2 people deciding. That's a benefit because it has an increased chance of making a better decision. Well, on the flip side of that is 2 people will have to make a decision, and they may both just not see eye to eye. So in those situations, when that happens, it means that if a decision isn't made, then it's not going to get done. And the impacts of that can be pretty significant, especially if we're dealing with, money is one thing, but in the context of medical decisions. Like, can you imagine if there's a loved one that's laying in the hospital that needs some life-saving care, and you've appointed 2 co-executors who have different opinions on what should happen? That means that mom, grandma, dad, whoever it is that needs that care won't get it until they can come to a decision. So it could really have some pretty significant impacts. Taking into consideration distance, right? If you have someone that, you think will be great, maybe they're a doctor, but they live in California. Well, in a case of an emergency, it'll take them some time to actually get here. So it's not to say that you can't name them, but it's something that you should really take into consideration and weigh among all of these other considerations, if that would truly be the best person, given the circumstances. Age, right? You have to look at your family. It's like naming someone who's about the same age as you may not always be a great idea, right? Sometimes people may not have another option, or they would really prefer to say, you know what, if something happens to me in the next 6 months, this person's completely capable. Totally fine. But that also goes to my point of why I recommend we name at least 3. So if something happens to that person, you still have a couple of options that the documents can point to. And note that 3, there's no law that says that you have to have 3. It's our recommendation. You can certainly have more, but 3 is kind of the general goal that we advise. Okay. Next slide here, family dynamics. Does anyone feel comfortable putting in the chat? Anyone have some wonky family dynamics? Yeah. That's a common thing that comes up. Family relationships matter. They do. I can't tell you the number of clients that I've had recently that have an estranged adult child, or maybe siblings aren't talking to one another, or there's a parent who I actually had someone who had to get a restraining order against their adult child. So they've been cut out of the from receiving an inheritance. These are real life situations that can happen. And doing estate planning, it's not a fun topic, but this can also be a really kind of jarring reality check, right? And thinking through the good, the bad, and the ugly when it comes to your family, but it's really important part of the process. And taking that into consideration when you're doing your plan. Who are your beneficiaries going to be? How are they going to be inheriting? But then also who you're putting in place to make those decisions and carry out your wishes, right? We need someone who is going to be clear in their communication, reduce the chances of resentment, choose neutrality over popularity. That's a big one. Being transparent, not being secretive, it reduces the chances of suspicion. Someone that's logical, someone that has loyalty, who that even if they disagree with what your wishes are, that they will respect the fact that that those are your wishes and they will carry it out, right? So one of the things here, transparency reduces suspicion, right? And planning conversations can also reduce chaos later. It may not be an easy conversation for you to have with your family of like, hey, I'm doing my estate plan. Here's what I've put down that's going to happen. And I want everyone to understand what it is. They don't have to agree with it, but if they have the opportunity to understand what they're expecting to happen after, if you become incapacitated or pass, it takes away the surprise. And taking away the surprise can reduce the chances of, wow, I really thought I was going to be named as trustee, but it was her instead, right? Especially at a time when we're dealing with money and we're dealing with grief, if we take that surprise element out, it can really help. Something that we also want to take in consideration here is second marriages, blended families. How do both sides get along? Are there other dynamics at play that we need to take into consideration here? So some practical tips. Have a meeting with your family when you put your estate plan in place. Let them know what's going on. Let them know what to expect. Tell them where you're putting your important documents. We actually have fiduciary letters that we send out to all the people that have been named in the plan to put them on notice. Like, hey, at some point in time in the future, you may be called upon to be a trustee for this person. You may be called upon as a guardian. So it doesn't come as a surprise to them if and when the time comes. Another thing that you can do is if you have a trusted relationship with professionals, estate planning attorney, accountant, financial advisor, whatever, those are, again, that's kind of the top three in this arena that we're talking about. You can introduce your family to those professionals to help bridge the gap, especially in a time of grief when this becomes necessary to kind of implement and carry out the wishes. Having that established relationship beforehand can also be beneficial. Okay. Next. So, setting your chosen representative up for success. What does that look like? Tell them they've been named. Tell them what they can expect to be obligated to do. Maybe walk them through the documents. We don't recommend giving them a copy of the documents. Here's why. One, you may need to make changes later. And two, if you do need to make changes later, they may not know where their copy is. And we want to avoid the situation where maybe someone forgot that there was a newer version and then an older version's used. So we really want to keep a tight lid on where the originals and copies are. As I mentioned earlier, also key contacts. One of the things that we do is we make sure that the people that are named in the plan, whether they are a trustee, a guardian, a beneficiary, whatever the case may be, we gather that contact information. Let's not make the job of the fiduciaries that you're naming even more difficult. Another point on that is like asset information. There's lots of money sitting in unclaimed property across the United States because people pass away and the people they leave behind didn't know what mom, dad, aunt, uncle, grandma, grandpa, whatever the case may be. They didn't know what they had. So keeping your documents, keeping them organized, keeping them updated, and keeping them in a place where it can be accessed by the people that you're putting in charge. Okay. For those that have been asked to serve, right? There's things that can help make your job easier. So I'm jumping ahead. This is why I usually don't use slides and when we do stuff in person, because one thing leads to the next. So I already touched on some of these here. But really, keeping up to date and understanding where the debts need to be paid, the taxes that need to be paid, managing and distributing the assets that are there based on the inventory that's there, and keeping everyone up to date with where things stand. Really, really important. So for those of you that have been named, based on what we've talked about so far, I would love to hear in the Q&A, has anyone been discouraged or scared from serving in the role that you may have been named? And it's okay if you are. That's okay. It's an unknown territory for a lot of people until they do it themselves. And let me know if you're seeing anything coming in the Q&A. I know there's a
Nothing just
delay.
yet, but yeah, there's a little
Yeah.
bit of a delay.
Yeah.
But
All
we
right.
definitely have some questions. Oh, here, let's see, what do we have here? Oops. Okay, that's a question. Okay. We could ask this question now because it sort of relates here.
Yeah, perfect. Go for it.
Yeah, she's curious. Aisha is curious about what I said about spending some of my personal money, meaning some of the money that I was able to take as the personal representative to fulfill her role as executor. What can the document creators do to make sure executors are not coming out of pocket?
So, kind of twofold there. And sorry, there's a couple things. First thing that I want to address is the part that Aisha, you had a question about taking money away from Anne. So by law in Maryland, when someone's going through the probate process, there is a cap on fees that can be charged. So a personal representative can be paid and compensated for the services that they're providing on behalf of the estate. An attorney can as well. But for some reason, Maryland has lumped those things together and created a cap for them collectively. So it's 9% for the first $20,000 in value, then 3.6% for anything above the $20,000 in value. And that is the value of the estate that's going through the probate process. So some personal representatives may say, you know what? I would prefer to not take all of this money and allocate some or all of it to an attorney to help provide their legal expertise and services and really take some of the lift and burden off of their shoulders to help make sure that the right things are being done, the filings are being made, distributions are being made accordingly, and also just interpreting the legal document itself can also be a big role. So also know that the statutory limits that are in place are for run-of-the-mill situations. Unfortunately, sometimes there's really complex situations that come up that require kind of above what a standard probate process would require. And in those instances, you can actually petition the court to get fees awarded above those statutory thresholds. So, and then, and I know there was a second part to Aisha's question. Would you mind kind of repeating that?
Yep, oops, sorry. And just for folks who are concerned that there were other questions, we are going to get to them. We have time for questions, so don't worry. I'm just trying to pick something that was relevant to what Malini was talking about. Oops. Bear with me 1 second.
Sure.
There we go. Okay. So the second part of the question, what can document creators do to make sure executors are not basically spending out of pocket?
Cool. Thank you.
Mhm.
So the document itself can say, you know, expenses are to be paid out of the estate. That is a common thing that should be in the document. Unfortunately, the document saying that doesn't mean that there are sufficient funds in the estate to pay for it. Sometimes we see estates that have a high value of assets, but they're not actually liquid assets.
Mm-hmm.
So when you're looking at your estate, really to the extent that you can, not that I mean, it's really difficult to put documents in place and then know your exact financial situation and asset situation at the time that you pass, right? Like that, it's just a kind of a weird thing to figure out. But in looking through your assets, making sure that you have something that's there, or to the extent possible, making sure that you have something that is liquid to be able to pay for the expenses, taxes, and other obligations that the fiduciary will have to make sure that they take care of. All right, couple more things here, guys, and then we're going to get to the question and answer portion. I'm sure there's a lot of, I know Anne said that there was a bunch of questions, so let's move through this so that we can get to that. Challenges and how to manage them. Time commitment and paperwork, right? As Anne said, it's a job, right? You have to take into consideration, you know, if you have been named as a trustee or other fiduciary, what's happening in your life right now? How much of an impact will it have to your life? Right? Is it something that you can handle? Are dealing with personal liability risk something that's acceptable to you? What if there's complex assets or debt situations? Or maybe the family dynamics may set up for a situation where you're expecting potential conflict, right? All of those things are something that you have to take into consideration. Just because you're named does not mean that you have to say yes. I'm sure the person that named you will appreciate it, but if it's too much for when the time comes, it's okay to decline. You just because you're named in a document does not mean that you are absolutely required to do so, right? Something else that can help take some of the burden off, as I had mentioned earlier, use professionals that can help guide you and they can help reduce some of that fiduciary personal liability risk, right? And again, that's the attorney, financial advisor, and accountant. And the financial advisors really come into play mostly when we're dealing with trusts because they have longevity and continuity rather than just an outright distribution. Certainly, when there's an outright distribution, a person who's receiving that inheritance with that outright distribution may want to work with a financial advisor to figure out, like, hey, I came into a pile of money. What's the best way that I handle this, invest it, etc. But certainly the trustee can also have that relationship on behalf of whatever assets are in that trust. So another really important part of this is keeping records, right? As I mentioned earlier, being organized. Every single thing that is done, money that's coming in, money that's going out, documents that were received, all things that need to be kept, keep the records of in case you have to prove to a government authority, in case there's conflict amongst beneficiaries, you can show that you have everything and what's been done or not done. So tools and resources. Here's just a very high level checklist of things that would be useful for the people that you are naming, right? Provide them with a trustee or executor checklist of the tasks that will need to be done. Keeping them up to date with who the people are that you've named in your plan. It could be other trustees, successor trustees, it could be guardians, it could be, the professional advisors that you've worked with, and then keep them organized with what the documents are. So those are some of the 4 key areas in which you can make things easier for the people that you're putting in charge. So how do we help people? We help people, walk through the estate planning process as well as the probate and trust administration process. But doing family meetings, telling them what it's all about, what to expect, education. This is an area of law that is very proactive, right? It's different than getting a speeding ticket. It's different than having a DUI. It's different than getting a divorce, right? Whatever those situations may be. This is something that really should start from a place of education because there are many options out there and considerations that go into putting not just a plan in place, but putting a plan in place that works the way that you want it to work in the way that you need it. And that requires education and thinking through all of the different considerations so that you can make the best decisions that are aligned for your goals, for your family, and for your assets. Okay. One other thing before we start to close here is, as I said, it's not only important to have the right plan in place, but make sure it stays updated. This is not something that should be shoved in the back of a drawer and then forgotten about. Here's an example. I actually had a client that came in who had a pretty well drafted plan in place with another attorney before we met. But the very first trustee that they named in their plan unfortunately had a stroke a couple years ago, and it became evident that she would no longer have the capability to be able to actually serve as a trustee. It would just really be too much for her based on her current medical condition. So it was really important for them to actually make a modification for their plan to get a new person in place. So we recommend a cadence of every 3 years. 3 years to review your plan. What's changed in your life? What's changed in the lives of the people that you've named, either as beneficiaries or fiduciaries? What's changed to your assets? What's changed to any laws that are impacting your life or your assets? Most of the time, it's like tax laws that are impacting the estate planning process, but it could also be some more substantive laws that can impact estate planning as well. So really, it's something that you have to keep up with. I would rather you look at it every 3 years and decide, you know what I have here is good, than find out years down the road that it really should have been updated. So, all right. Thank you all very much for coming and attending, spending your time to learn about this stuff. Really, really important. We're here to be a resource for those of you if you'd like to learn a bit more about this area or ready to talk about what that would look like. But really, our goal for you is to be educated and to make a decision of who would be best in working with you to put that plan in place so that you don't leave your family with a mess. All right, Anne.
That's great.
So
Malini,
let's hear
thank you
some
so
Q&A.
much. This was great
Absolutely.
to really get a deep dive. And I am again reminded of something that someone said just yesterday, which is I know that one of the concerns people have is like, oh, this is expensive, but the question or the comment was, we pay for what we value. And when you think
Yeah.
about this being your life savings, all of your wealth, you want to make sure that you're just like you pay car insurance because you don't want your car to get crashed or your house
Yeah.
to come down. Yeah. So let's jump in. I know we have some questions and people are anxious to hear your answers. The most upvoted one was, if I have my assets, bank accounts, 401k, house listed with beneficiaries, I thought that would say probate. You said the executor will handle probate. Prior session tried to educate us on how to avoid probate. Can you elaborate?
Yes. Okay. So there's two main things from that question is one, if I have beneficiaries, isn't that good? And then two, how to avoid probate. So having beneficiaries is a very, very vital part of the estate planning process. However, it is not an estate plan. There's a big distinction there. Big, big distinction there. One of the things I said earlier is usually people are naming their family, their close loved ones as beneficiaries, but they are also the ones that travel together. So if you are naming the people that are in your life and you're traveling together and something happens and you've blown through your beneficiaries, what happens? All of your assets will then go through probate and then the state decides where your stuff goes. This all comes down to a choice. Once you understand what the options are, you then get to decide what works best for you. Some people may say, you know what, the chances of that happening, I don't think are very high, and I'm willing to accept the risk. That's a personal choice. Personal choice. Some of the other considerations here is, or before I get into that, if you prefer to go with the beneficiary route as the primary way of doing an estate plan, we recommend at minimum putting that will in place. That way the assets go where you want it to go instead of the government deciding in the event that something happens to all of your beneficiaries. Another consideration here is when you are naming beneficiaries, it doesn't provide an opportunity for asset protection. Estate planning is a really good spot to be able to do that for the people that are inheriting. You can protect it from future spouses and divorces. You can protect it from creditors, lawsuits, and bankruptcies. But if you name someone as a beneficiary, as a direct beneficiary, that eliminates the opportunity for asset protection. Another common thing that we see is naming minor children as beneficiaries. Perfectly fine, but the problem is if they're under 18, they can't own it. And the moment they turn 18, unless you've put a plan in place that makes a different decision, they will receive everything outright at 18 years old. I don't know about you guys, but personally, I don't trust many 18-year-olds with $5,000, let alone what could be several hundreds or millions, several hundreds of thousands or millions of dollars. Something else is we see frequently that people name their adult sister or parent that's meant to be for the benefit of their minor kids. If you wanted to go to your kids, you have to name your kids or put some other plan in place, because what if the person that you named is going through a divorce and that's an asset that they inherited, right? That really was meant to be for someone else. So make sure that you are naming the people that you want to actually receive it instead of kind of trying to create a workaround. I know people have the best of intentions, but sometimes things just go sideways. And at the end of the day, it could be your kids that get hurt because something didn't go as expected. Also, if you're naming people that have special needs, or maybe they don't now, but have special needs that come into the future, if they receive an inheritance, it could potentially kick them, like as an outright distribution, it could kick them out from continuing to receive those government benefits, which can be a really, really big deal. All right.
Great.
I hope that answered your question. I know that was a lot. It was a very
There's
loaded one.
yeah.
There was
No, it
actually
was
another part. How to avoid probate, right? Beneficiaries is a way to avoid probate so long as the circumstances play out in the way that you want them to. I don't know about you guys, but in my experience, that doesn't always happen. So that's maybe a way of avoiding probate, but also only, again, if certain circumstances occur. So the main and safest and primary way to avoid probate is to have a revocable living trust, right? That is the primary go-to and how to do that. Yeah. All right, next question,
Yep.
Anne.
And then you have to make sure all your assets are titled to the trust and not to individuals.
Yes,
But
yes,
yeah, that's
yes,
down in the weeds. Okay, another one.
yes.
What options or recommendations do you have for an executor if it's not a family member or a friend? Who else? And I think you said there are businesses you can
Yes,
have, but who else might there be?
that's really kind of the options,
Pretty
right?
much it.
It's family,
Yep.
it's friends, or you name a business.
Okay. All
I,
right.
I don't recommend picking a random person on the street.
Probably a good idea.
Yeah.
So, this is somebody who missed a couple of sessions. Hope it's not a duplication. No, it's not. So, University System of Maryland Benefits have provided through AD&D and Life provider will documents. I also have a financial advisor. So, why do I need an estate representative? So, I think
So
maybe that's
I think just based on the question, and maybe I'm misinterpreting it, sounds like there's some confusion about what a financial advisor does versus an estate representative, right? Financial
mhm,
advisors providing professional services. They can provide services to people that are living. They can provide services to people who are serving as an estate representative on behalf of the assets that they are in charge of managing and controlling. An estate representative, that's kind of the general term, but really someone serving as an executor or personal representative of a will, or you're serving as a trustee of a trust, or you have been named as a financial power of attorney, meaning that you are responsible for making financial decisions for a person if they're alive but incapacitated, right? Then there's the medical power of attorney as well. There are the people that will make the medical decisions for you when you're unable to do so yourself, but you are alive and incapacitated to do so.
all right. I'm going to jump because this is going to be a super quick answer, I hope. How long do you have to keep records if you are the estate representative?
So we recommend holding on to things it like at least through the end of whatever it is. And really the length of records that you hold on to is going to be somewhat dependent on what's happening, right? If it's a probate that doesn't have a testamentary trust, that's a lot different than a revocable living trust that has an asset protected trust that's meant to go from one generation to the next. So the record keeping is something that we always err on, even to the extent that there may be statutory limits of you have to hold on to records for this period of time. We always find that it's better to hold on to them for longer rather than not,
Yep.
especially in a digital age, right? It makes it pretty easy. We don't necessarily have to have boxes sticking around.
Absolutely. Okay, we've got a couple more. I'll just have to pick. Um, we have like a minute left. Can you have a co-representative with a tie-breaking decision maker? So again, I think what that's really saying is pick somebody and let that person stand in place.
Yeah, so yes, but then again, it's especially in a medical situation or something that's more time sensitive. If two people that you've named can't make a decision and then you're bringing a third person into the mix, certainly it can be a way to be a tiebreaker. But from the reality and logistics of it, you have to consider if the benefits of having two people named outweigh the potential risks and consequences. And that's a personal decision for everyone.
Yep. And I'm going to have to choose this to be the last question. Malini has her contact information up there if you want to follow up with her on any of these. But someone just was curious to know, is there a book you can recommend to help understand all of these topics from the entire week in a comprehensive way? Like an estate planning for dummies kind of thing? Is there such a thing?
I will admit I do not have one off the top of my head. I
Mhm.
spend the resources that I use to educate myself and expand my body of knowledge in this area are pretty dense legal material. So that's something I'm happy to do a little bit of research and pass that information along to Anne if I find something that I think may be a bit more kind of estate planning 101 and easily digestible. But Anne, if you don't mind, I do regular education seminars and we provide a lot of educational content through our newsletter, through our social media, through our blog post, where it's another good opportunity to kind of learn about this stuff in a more easily digestible format.
That's a wonderful offer. Thank you so much. And again,
Absolutely.
thank you, Malini. This was great. I appreciate it. She's actually on the road today, beaming in from Austin, Texas.
Yeah,
So I'm thrilled that you were able to work this in. It was a really
definitely.
important topic. And thanks to everybody for being part of this week. I hope you found it useful. Again, we're going to send out the email with the links to all the recordings. Please go back and watch them. We presented a lot of material, and I know it was a lot to take in at once, but and then please fill out the survey. So thank you all so well. Be well, get your plans in place, and I hope you have a great afternoon. Take good care.
Thank you.